We are sitting today to deliver the sentence judgment of Ranko Češić. What now follows is only a summary of the written judgment and forms no part of it. The written judgment will be made available to the parties and to the public at the end of this hearing. We will now briefly set out the context and the facts of the case, as well as the factors the trial chamber considered in imposing the sentence. Ranko Češić was born on the 5th of September 1964 in Bosnia-Herzegovina. He lived in the Brčko municipality before and during the war and moved to Belgrade towards the end of 1996. Ranko Češić was first indicted together with Goran Jelisi in a joint indictment confirmed by Judge Vohrah on the 21st of July 1995. Goran Jelisi was tried and convicted on the 14th of December 1999. An amended indictment pertaining only to Ranko Češić was filed on the 26th of November 2002. The indictment is comprised of 12 counts. 6 counts charge Ranko Češić with crimes against humanity. 5 of these charge murder and 1 charges rape. 6 other counts, referring to the same events, charge Češić with violations of the laws or customs of war. 5 of these charge murder and 1 charges humiliating and degrading treatment. Ranko Češić was arrested in Belgrade by the authorities of the Federal Republic of Yugoslavia on the 25th of May 2002 and was transferred to the United Nations Detention Unit at The Hague on the 17th of June 2002. At his initial appearance 3 days later, Ranko Češić pleaded not guilty to all counts of the indictment. However, on the 7th of October 2003, before the beginning of the trial, Češić and the prosecutor entered into a plea agreement. Ranko Češić admitted his guilt on all 12 counts and agreed to testify in other proceedings before the tribunal. A written factual basis described the crimes and Češić's participation in them and was annexed to the plea agreement. Češić subsequently pleaded guilty to the 12 counts of the indictment before the trial chamber on October the 8th, 2003. The trial chamber accepted the guilty plea after having ensured that it was made voluntarily, was informed and unequivocal, and after verifying that there was a sufficient factual basis for the crimes and for the accused's participation in them. A sentencing hearing was then held on the 27th of November 2003. The acts for which Ranko Češić is sentenced today took place in the Brčko municipality located in the northeast of Bosnia-Herzegovina in May 1992. At this time, Češić was a member of the Bosnian Serb Territorial Defense in Brčko. On the 15th of May 1992, he became a member of the intervention platoon of the Bosnian Serb Police Reserve Corps at the Brčko police station. His exact role and rank within this corps is not known. According to the agreed factual basis, Ranko Češić committed 5 criminal acts between the 5th of May and the 14th of May, and 1 criminal act sometime between the 14th of May and the 6th of June 1992. These acts took place while the Serb forces in Bosnia, from the 30th of April onwards, engaged in the takeover of the municipality of Brčko. During this operation, the Serb forces forcibly expelled and transferred the Muslim and Croat residents of Brčko to collection centers. These collection centers included the Luka detention facility and the Brčko Partizan Sports Hall. Ranko Češić criminal acts were committed against persons detained at these two collection centers. Češić has been convicted of the murder of Sakib Bicerovic and of 4 other men at the Brčko Partizan Sports Hall on or about the 5th of May 1992. These murders constituted a violation of the laws or customs of war and a crime against humanity. Češić has also been convicted of the murder of a detainee at Luka camp named Sejdo on approximately the 11th of May 1992. This murder constituted a violation of the laws or customs of war and a crime against humanity. Thirdly, Češić has been convicted of the murder of a Muslim policeman named Mirzad, detained at Luka camp on approximately the 11th of May 1992. The victim, who was detained in a hangar together with the other detainees, was first ordered by Ranko Češić to say goodbye and shake hands with the other detainees. He was then taken out by Ranko Češić, another Serb policeman, who beat him and killed him. This murder constituted a violation of the laws or the customs of war and a crime against humanity. Ranko Češić has also been convicted of humiliating and degrading treatment as a violation of the laws or customs of war, and of rape as a crime against humanity, for having forced, at gunpoint, 2 Muslim brothers detained at Luka camp to perform fellatio on each other. This act was committed around the 11th of May 1992. The 5th criminal act Češić has been convicted of is the murder of a Muslim detainee at Luka camp named Nihat Jazarevic. This man was beaten to death with clubs by Češić and another Serb policeman. The murder constituted the violations of the law or customs of war and a crime against humanity. Finally, Ranko Češić has been convicted of the murder of at least 2 detainees at Luka camp. Ranko Češić admitted that sometime between the 14th of May and the 6th of June 1992, he took 4 detainees out of the Luka camp's office building, led them to the paved road in front of the main hangar building and, with the assistance of 2 guards, shot and killed at least 2 of them. These murders constitute a violation of the laws or customs of war and a crime against humanity. In total, Ranko Češić has admitted to killing 10 individuals, 2 of whom died as a result of beatings, and to having forced 2 brothers to perform a sexual act on each other. He committed all these crimes within a period of 10 to 32 days. The trial chamber has considered the purposes of punishment in light of the mandate of the tribunal. In accordance with the jurisprudence, retribution, deterrence and rehabilitation have been considered as relevant purposes of punishment for international crimes. Turning to the sentencing factors, the trial chamber first considered the gravity of the crimes, with reference to the particular circumstances of the case, as well as to the form and degree of participation of Ranko Češić in these crimes. Češić is convicted for having personally committed 10 murders, constituting 5 crimes against humanity and 5 violations of the laws or customs of war, and for 1 sexual assault, constituting a crime against humanity, rape, and a violation of the laws or customs of war, humiliating and degrading treatment. These crimes are particularly serious in terms of the protected interests violated, the life as well as the physical and moral integrity of the victims. The crime of murder is inherently serious, and a conviction for multiple murders, of course, further adds to the seriousness of the crime. In relation to the sexual assault, the fact that the victims were brothers, that they were forced to act at gunpoint, and that they were watched by others, means that this offence was particularly serious. The prosecution submitted that in assessing the gravity of the crimes, the trial chamber should also take into consideration the impact the crimes had on the victims' relatives and friends. The appeals chamber has said that such impact may be taken into account when determining the appropriate sentence. The trial chamber considers that the impact of the crimes on the victims' relatives and friends is among the factors that have been already taken into account when evaluating the inherent gravity of these crimes. For example, it is among the factors taken into account in concluding that murder is a particularly serious offence. The prosecution invoked as aggravating circumstances the vulnerability of the victims and their civilian status, the purposefully cruel conduct of Ranko Češić, the humiliating character and unusual depravity of the sexual assault, the fact that Češić abused his position of authority, and the recurrence of his criminal conduct over a period of at least 10 days. The defense claimed that these were not aggravating factors in this case. The trial chamber takes into account that the victims were all detainees, placed under the oversight of Bosnian Serb soldiers and policemen, and were thus particularly vulnerable. Češić's depravity and cruelty, as shown by his beating of some of his victims, and his forcing a detainee to farewell other detainees before being taken out and executed, were also considered aggravating factors. As for the incontestable recurrence of Ranko Češić's criminal behavior, the number of crimes committed by him within this short period of time has already been taken into account in evaluating the gravity of the crimes, and hence should not also be considered as an aggravating factor. The contention that Češić abused his position of authority and that this should count in aggravation is also rejected by the trial chamber. Ranko Češić's exact position in the military or police hierarchy is unclear, but he was undoubtedly of low rank. Ranko Češić's admission of guilt his substantial cooperation with the prosecution and his expression of remorse are the factors which the trial chamber has taken into consideration in mitigation. The defense raised a number of personal circumstances in mitigation, namely the fact that Mr. Češić was brought up by a single parent, that he's currently married, that his low income would prove that he did not personally gain from the conflict, or that he was only 27 years old when he committed the crimes. The trial chamber has not found that these circumstances merit mitigation of punishment. The trial chamber has also rejected the submission that Češić's guilt is lessened by the fact that he merely executed orders when committing the crimes. Good character was also not established. A guilty plea helps establish the truth and may aid the process of reconciliation in the Brčko municipality. More particularly, it may provide a sense of relief to the surviving victims and the victims' relatives and friends. It also saves the witnesses from the possible trauma of reliving the events when testifying in court. The guilty plea was entered some 16 months after Češić's initial appearance, but nevertheless still before the commencement of trial, thereby saving time, effort and resources. For all these reasons, the trial chamber finds that Češić's guilty plea is an important mitigating factor. As for Češić's cooperation with the prosecutor, the trial chamber, in the absence of any information to the contrary, relies on the prosecutor's declaration that Češić provided a full and complete interview to the prosecutor concerning his knowledge of war crimes and other violations of international humanitarian law in and around Brčko during the armed conflict in Bosnia and Herzegovina. The trial chamber also takes into account Češić's commitment to testify in other cases, if called by the prosecutor, and concludes that his cooperation with the prosecutor is substantial. Ranko Češić expressed remorse for his criminal acts at the sentencing hearing of the 26th of November 2003. The trial chamber believes that his expression of remorse was sincere. The trial chamber has carefully reviewed the statements and documents adduced in evidence by both parties in respect of the defense submissions regarding Ranko Češić's good character. The trial chamber finds that the evidence submitted by the prosecution does not successfully rebut the evidence adduced by the defense in support of its claim of good character. On the other hand, while the evidence presented by the defense, along with that concerning Ranko Češić's behavior at the United Nations Detention Unit, shows that Ranko Češić is capable of benevolent and good behavior, the trial chamber finds that the evidence presented demonstrated at the same time the unpredictability of his behavior. On the balance of probabilities, the trial chamber cannot conclude that Ranko Češić is of a genuine good character, so as to allow this good character to be taken into consideration as a mitigating factor. Finally, the defense referred to a statement given by Ranko Češić to the prosecution in September 2003, in which he stated that he merely pulled the trigger, but that others took aim. According to the defense, this statement establishes that Ranko Češić acted pursuant to orders, and that he would have been killed if he had failed to execute these orders. On the balance of probabilities, the trial chamber finds that the statement does not establish that Ranko Češić acted under duress or pursuant to orders. The prosecution has recommended a sentence in the range of 13 to 18 years and has agreed not to appeal any sentence imposed within this recommended range. The defense requested a sentence of 13 years and agreed not to appeal the sentence unless it is above the range recommended by the prosecution. The trial chamber is not bound by any agreement between the parties on the sentence. Mr. Češić, would you please rise? The trial chamber has carefully reviewed the factual basis and the evidence presented by the parties. The sentence you receive should be proportional to the gravity of the crimes you committed. In addition to the gravity of the crimes you committed, your victims were all detainees placed under the oversight of you and other Bosnian Serb soldiers or policemen. You knew that your victims were particularly vulnerable. These considerations constitute, in the Chamber's view, aggravating circumstances. The trial chamber finds that your guilty plea, prior to the commencement of the trial, your substantial cooperation with the prosecutor, and your sincere expression of remorse are mitigating circumstances. Finally, in determining the sentence, the trial chamber has referred to the general sentencing practice of the courts of the former Yugoslavia. The trial chamber hereby sentences you, Ranko Češić, to a term of 18 years of imprisonment. You're entitled to 657 days credit for the time you served up to and including the day of this judgment. Please be seated. This concludes this session in which the chamber delivered the sentencing judgment of Ranko Češić.
All rise, veuillez vous lever.